get the show on the road and see what we can cover this evening. Let me just make sure I'm organised this end. Okay, well this is where I am at the moment. This is the Royal Library in The Hague. So it's actually 10 o'clock in the morning with me, and I'm sitting in the offices of IFLA, the International Federation of Library Associations. So I'm here to run some workshops with people from all across the world, but while they're enjoying a very leisurely breakfast, I'm here working with you. So hopefully we'll have a productive time, and there's no blue sky like that unfortunately today. It's very grey and very cold. But, so let's really do the things that we're here for. The program for tonight, we're covering two modules, well, it's actually two sections. I should say module 1, legal citation. It shouldn't say module 2. That was my error. I've been very tired last night. I'm sorry. So we've got two sections. We've got legal materials, and then looking specifically at primary sources. And we're also going to look at legal citation. Next week, we'll actually have module 2, and that is secondary sources, which is obviously the wires got crossed last night. And there's a whole load of activities for you offline after the class. There's lots of materials on Blackboard for you to explore. There's some practice exercises as well, which we'd like you to have a go at. And obviously, you've presumably still got some work on assignment 1 to do if you're doing that. So plenty to keep you busy offline. And then in the second half of the session, we've got another guest interview. Richard is with Legal Aid Queensland, and unfortunately he wasn't able to join us for the panel last week, but he's got some very interesting perspectives of legal research in the legal aid sector, which is quite different again from sort of academic law libraries and law firms and the courts. So we'll capture his views, hopefully, on that as we go through. So what we want to look at this evening, therefore, quite quickly, hopefully, is primary sources. You've heard us talk a little bit about this already, that we talk around primary sources and secondary sources. So primary sources include legislation, also delegated legislation, and then case law. So the primary aspects of legal materials, the two main ones are the law as it's made, so legislation, and then the law as it's interpreted, so legal decisions, case law, etc. And so next week we'll cover a lot of those other things as well. You will notice that on Blackboard, and certainly I think it was in last week's materials to do after class, there are a couple of videos and quite a number of resources around how the law is made. So if you didn't get a chance to have a look at those, then please do so, because that will explain it to you. But it's a very fundamental aspect of legal research that you do understand the process in which all of these materials are created and distributed. So, again, we go back to the Constitution, and if you recall, the legislative power is vested in the Parliament. So under the Commonwealth Constitution, then that's where the Federal Parliament, and that includes two houses. You've got the House of Representatives as the lower house, and the Senate as the upper house, and then the Queen as head of state. Similar provisions in the states. But, of course, in Australia, the Queen doesn't play an active role. Sorry. When legislation is passed, it goes for signature. Just hold on a minute, sorry. I've got my throat there. It's still there. Hold on a minute. Must be the cold air over here at the moment. Sorry. So royal assent is the term that is used when the act, as it's actually finally made, is signed off, if you like. It's presented for official signature, and that is termed royal assent. So in Australia, because the Queen doesn't actually have an active role anymore, since the Australia Act in 1988, the Governor-General for the Commonwealth, or the Governor of the state, is the person who has responsibility for providing that sort of stamp of approval that it has been assented to. So a piece of legislation does not become law until it has received assent. And that doesn't necessarily happen immediately. And that's one of the little sort of quirky things you have to be aware of in legal research, is that you need to really verify whether an act as passed might be sort of already passed by the Parliament, but there may be a time lag before that assent comes into as an act in force. So, but there'll be more about that as we work through some of the activities. So the journey to become a statute, we start off with a bill. So a bill is the term that's used for a proposed law. And you, obviously, if you're listening to the news or watching the news, you very often hear about a bill being introduced into Parliament. Generally, it's done by a member of the ruling party in government, but not necessarily. You can have private members' bills. They can be introduced into the Senate. There's lots of different pathways. But the bill is the document that is worked through and ultimately passed by the legislature, by the Parliament. And then it goes off to receive assent. So there's a typo in there as well. So it's called a statute or an act of Parliament. So proposed changes to the law can be initiated by a lot of things. Very often there's social, business or professional pressure. So one example would be after the Port Arthur massacre, the steps that were taken to remove guns from the community in general, to introduce new gun laws. So that would be one example. Social pressure at the moment you'd be very aware of around equal marriage opportunities of sort of gays and different types of people getting married, as opposed to traditionally just a man and a woman, etc. So that's another example of society. There's reports from the Law Reform Commission. The Law Reform Commission is exactly what it does. It's a commission that reviews the law with the goal of seeking to have reforms brought in. So that's the sort of pathway to really critique, review how society has changed, how issues have changed, and the Law Reform Commission can make recommendations for new laws to be introduced. The public service itself has the ability to introduce some new legislation, and then the political parties, that's part of their role, say the caucus, is to consider areas where they do want to introduce new legislation. So in terms of legal research, you do need to understand the pathway of what happens to a bill until it becomes legislation, just in general. There's some good videos on this, so I won't spend a lot of time talking about it. But basically, the speed of the process can vary. Sometimes a bill can get pushed through very, very quickly. Other times, if it's not an urgent issue, it may sit around, so to speak, for quite some time before it's actually all finalised. But the ideas sort of come together and are discussed at cabinet meetings. The bills fall into the portfolio responsibilities of the different ministers. So if it's an environmental bill or if it's a corporate law bill, it'll fall into those different ministries. And then the materials are gathered to make sure that there's been enough coverage of the issues. And then the drafting is, so that's the writing. The writing of the draft legislation is prepared by the Office of Parliamentary Counsel. So not by the ministries or the government departments. There's an office to actually work through and complete that work. So the content of the bill, so the ideas that have been discussed at cabinet meetings need to be translated into legislative language. These days there's a much stronger push for plain English, and so it is easier for people to understand. And then the bill is approved by cabinet. Then, once it's introduced into the daily program, notice is given and then a time is appointed for it to be introduced into generally the lower house. Then it goes through these different steps: the first reading, second reading, consideration in detail, third reading, and then it would move on. If it's a bicameral legislature, it will go to the upper house and go through a similar process, and ultimately when passed it receives assent. So you'll see quite a lot talked about specifically the second reading, and we'll explain a little bit about that as we go through. So the first reading is when it's presented to the House. Generally there's an explanatory memorandum, sometimes referred to as explanatory notes, which is sort of discussion about it in sort of ordinary language to explain the purpose and the rationale and some sort of information that helps people interpreting the law. So even after a bill has been passed and has become an act, lawyers might well wish to come back to the explanatory notes. They also refer to all the supporting materials are referred to as extrinsic materials. So the first reading is basically that the clerk of the House reads out the long title of the bill. And there's very often a short title of an act and a long title of an act. And we'll introduce each of those in an exercise later. So then the copies of the bill are distributed and are made available publicly these days on the website. And then the Minister moves that the bill now be read a second time. Okay, that's when you come to the second reading. So the second reading speech is the key element of explaining the purpose, the principles, and the effect of the bill. And so that's a debate is then very often adjourned, but the debate itself gives the parliamentarians, the members of Parliament, the opportunity to present the two sides of the argument and to block it, potentially. If the opposition doesn't want the bill to go forward to become law, it may never actually get through to become an act. But assuming that the discussion goes through, the debate goes through, then the long title is read a second time. So there's your second reading, as it's referred to. Consideration in detail. This takes sort of part sort of away from things, if you like. It means the opportunity to work through each clause one by one and to enable changes to be made. So it might involve changing the wording, inserting some new ideas, etc. So, but some bills are really very straightforward and just go through very quickly with very, very little debate. It really does depend on the topic and the issues that are being discussed. The third reading comes after all of that consideration in detail, and the Minister moves that it be read a third time. And so the long title of the bill is read out again, and this signifies, the third reading is that the bill has passed the House. If there is a second sort of upper house, then, as I say, that process goes through again. Queensland, because we only have one chamber, just the lower house, then that would move automatically from that into sort of getting assent from the Governor of Queensland. So again, similar thing in the upper house and the assent. The bill is sent to the Governor-General, or in the States the Governor, and then it gets signed off, and it's like, in the name and on behalf of Her Majesty, I assent to this act. So that's the receiving assent. Another step needs to be made, which is the proclamation. So an act only comes into force either on the day that it does receive assent, or at a future date, a date to be proclaimed by the Governor-General or the Governor. And this is published in the Government Gazette. So again, doing your legal research activities, you need to be aware of whether an act is actually in force, whether it did commence on the day that it received assent, or whether at a later date to be proclaimed. And then you have to go off and seek to find the proclamation as published in the Government Gazette. Ultimately, the Act as it is now is published, printed by the relevant government printer. These days, much more electronically, of course, is available online. And one piece of legislation, one Act, isn't its final iteration, very often there will be amendments made in the future. Acts can be repealed through other amending legislation. So there's quite a lot of complex ideas that you need to understand. So obviously legislation that is no longer relevant to society needs to be repealed. So we'll also look at that process as well. So Parliament of Australia's got an info sheet, and I'd encourage you to go and have a look at that. And all of these different ones. This is just for Queensland, but you'd find for the different states, there's lots of documents which explain these different processes, the actual legislative process, how an act is made, etc. So plenty of resources. So the law, once it's made, then of course has to apply to people, and inevitably different people might interpret the law in very different ways, which can cause a legal issue and can ultimately result in the courts being asked to provide the definitive interpretation of the law. So you've got an act. What does it actually mean? What does apply in what situation? So generally the court isn't asked to interpret the whole act, but specific parts of the law which are directly relevant to a particular legal matter where there is some argument as to what it might mean. So this then goes to the judge to work out what is meant by the law, and what materials, if any, can be then used to help interpret, to ascertain the actual meaning. And so here again we need to stress that sort of the fact that the people who make the laws and the people who interpret the laws have to be very, very different people. So that's separation of powers, so that there's no overlap between those areas in the Westminster system. So there are some parliamentary aids to help understand how to interpret legislation. There's the statute itself, obviously, and there's a definition section that you can refer to, and some of the more complex ideas might be explained and defined in that sort of definition section of the Act. There are also things called interpretation acts, and these provide basic rules of the interpretation, so it doesn't have to be repeated in every single piece of legislation. So particular terms of expression, so where the male gender is used, it automatically includes the female gender. Where singular is used, then it automatically includes plural, things like that. So the interpretation acts provide all of that guidance. It refers directly to the use of extrinsic materials, as we mentioned just now, so the explanatory memorandum or the explanatory notes. You can refer as well to Law Reform Commission or Royal Commission reports, which have been part of the process leading to the introduction of new legislation. And then the Hansard. So the Hansard is the actual, the volumes where the second reading speeches and the debates are captured. And so they are often asked for as well. So you need to be able to go to your parliament and have access to the different Hansards. Again, most of them are electronic these days, so it's a lot easier than it used to be when you had to manage all the print volumes. Secondary materials obviously help in interpreting the law as well. So there are textbooks, dictionaries, law digests, encyclopedias, and all sorts of other aspects there. So delegated legislation, this is like regulations, bylaws, ordinances and rules. So they don't go through the Parliament itself. They're sort of made outside, generally sort of developed through the government departments. And that obviously saves the parliamentary time. It allows for the input of technical expertise because it's the application very often of the law is through the regulations. And also because it doesn't have to go through the Parliament, it's a faster response to changing conditions. If you think of traffic fines, for example, they will be outlined in the regulations, but if there's a need to increase certain traffic fines, it can be done really quite easily by changes to the delegated legislation, not through the principal legislation. The acts will also to bear in mind, we'll have an enabling section. So we advise you, obviously, to start getting your hands really dirty and looking at some pieces of legislation to consider the structure and compare two different documents to see what the similarities are, what are common sections of the piece of legislation. But there's an enabling section actually indicates who has the power to make the rules and regulations that are going to be in the delegated legislation. So some might be through the Governor-General or the Governor-in-Council, ministers. If it applies to local government, then very often the council has the direct authority to make those regulations. Some legislation refers to statutory bodies, so corporations. Universities, you'll find there's a QUT Act, Queensland University of Technology Act, there's the University of Queensland Act. All the universities have their own, so they can then make their own regulations under the powers that they have there. They are, of course, controlled and checked by the Parliament and in interpretation through the courts. So very often you'll have the main act and then the supporting delegated legislation. They need to be sort of connected in terms of how the law is applied. So in checking, doing the checks through Parliament, all delegated legislations, all regulations that are made, or rules or orders, must be tabled and laid before the Parliament for a certain number of days after making the regulations. So for the Commonwealth delegated legislation, it's 15 days. And then the regulations, there'll be a provision as to when they take effect from a specific date, and there are some provisions for disallowances. Sometimes there are committees set up to examine the delegated legislation, and there's processes involved in there, which we won't worry about now. The courts, we talk about the legislation being interpreted by the courts, but delegated legislation can also be tested to see whether it is intra vires or ultra vires, so whether it has the relevant legal authority. And again, here, rules of statutory interpretation may apply. And the courts have the authority to strike down any regulations which are actually found to be invalid. So you need to be aware of that. So the third area of primary materials, that's case law or legal decisions as going through the court. As you probably understand, it's the judges providing the reasons for the decisions. They're generally given in writing. Sometimes they're given orally and subsequently transcribed. So importantly to notice is that not every decision that goes through the courts that's made by the judges is actually reported in law reports, in published law reports. There's things we refer to as unreported decisions as well as reported decisions. So the ones that are reported, formally reported, there are councils of law report, and they have the responsibility to write up the materials correctly. And there are also legal publishing companies. So CCH, for example, has a whole swag of different legal services which include the cases, and they're written up that way. So once again, we encourage you to go and look at some real law reports to have a look at what they look like. And there's some terminology that you need to be aware of. So the court case refers really to the things that are happening in the court. It might be referred to as a legal matter or an action. And when the case is actually heard in court, then that is called a hearing. You need to be aware of the jurisdiction. So jurisdiction means the range of legal cases that can be heard by a specific court. So jurisdiction means whether it's a criminal court, whether it's a civil matter, whether it's an appeal case, that's jurisdiction. But of course the other interpretation of jurisdiction is geographic. So you'll talk about New South Wales as a jurisdiction, Western Australia as a jurisdiction. So it's a double-layered term that you need to be aware of. Now, in terms of the parties in the case, the plaintiff is the first name, the one who commences the legal proceedings, and the other party is the defendant. Okay, so you've got the plaintiff and the defendant. And then the plaintiff usually commences proceedings by asking the court to issue a writ, or there may be a summons or a statement of claim. Criminal cases, however, are different. Those are like civil cases, administrative cases. Criminal cases, it's really about finding out whether the accused is actually guilty. So you have the accused and the defendant, the appellant and the respondent in the appeal courts. So you need to become familiar with how those terms are applied. In terms of how law reports actually came into being, for several hundred years in England, there were yearbooks. So from Edward I through to Henry VIII, the yearbooks of the law being reported as as it was made through case law. But in Henry VIII, there were major changes, and the publications ceased. And what happened? So the government, the Crown, making writing it all up, etc. The recording and publishing fell to private enterprise. So you'll find there's a whole load of the several hundred years of law reports which are called nominate reports. They're named after the different lawyers. So if you do have to go back historically into English law, you'll find these nominate reports. But of course then it was found that different lawyers would do their own style of reporting. So there was a need to bring together and to make it much more synthesized, the approach that was made. So in 1865, the Council of Law Reporting was set up, and it was given the remit to produce authorized law reports. So here in Australia, the authorized law reports go through the Councils of Law Reporting, not through the publishing houses. So there's two different areas of law reports that you need to be aware of. So you do need to understand the difference between authorized reports and any other reports, which are still about the case, but they're not authorized. In the authorized version, the transcript of the case has been checked by the court before publication by the Councils of Law Reporting. So the text has been reviewed, revised by the judge, and very often there's a summary of the arguments that the advocates, the lawyers, have put to the court. Now, when a matter is heard in the courts, it's essential that the judge and the lawyers have exactly the same document, the same report of the case. Therefore, the authorized reports are those that are taken into court, even if the same case is reported externally by a legal publishing house, for example. So there's a little video on the Blackboard site which Shirin has added, which gives quite a humorous approach to the judge really sort of getting on top of the value, the integral value of having those authorized reports. So take a look there. So here's a listing of all the authorized law reports as opposed to some of the unauthorized law reports. So the Supreme Courts, the Courts of Appeal and the full courts, there's a whole series of law reports which are the authorized ones. So for the High Court, the Commonwealth law reports, and then you need to become familiar with all of these little acronyms. They're going to sort of haunt you forever. So the CLRs are the Commonwealth law reports, and the Federal Court, the authorized reports, are the Federal Court reports, so FCRs. If you drop down to the bottom of the slide, you'll see there's an unauthorized law report series, which is the Federal Law Reports. So Federal Court reports, Federal Law Reports. They may cover exactly the same cases that have gone through the Federal Court, but very importantly, you'll find that the authorized version is the one that has to be used within the courtroom. So the same for the Commonwealth law reports, they'll get reported through the Australian law reports and through the Australian Law Journal reports. So there's different sources. Then each of the states have got their series as well, so New South Wales, Victoria, etc., etc. So really become familiar with these are the sort of top of the range ones that you need to be aware of. So then the legal publishers have got their own different series of reports as well, their own editors and reporters, and they tend to be very much around different areas of law. So there'll be the company law reports, there'll be the Australian tax cases, family law reports, etc. So because of the areas of specialisation that lawyers these days, because of the complexity of everything, tend to specialise in specific areas of law, then the publishers are meeting their immediate needs by having very tailored materials that they don't need to know about all the different cases and things that are happening in other areas of law. So you can go and have a good browse through a law library to find out what there is. This slide just shows you the overall structure of a law report. So it's always presented in the same way, with the name of the court, the parties. Catchwords, these are like keywords in a way that provide a summary of the subject matter of the case. So if you're looking at different databases, these are sort of fields that you can then search on. The relevant legislation may well be included there as well, of course. The head notes is they're sort of more like an abstract is probably the easiest way to describe that. And it gives you more details about the facts and provides you with the decision, the actual outcome of the court hearing. And then also it notes the other cases that may be, and this is terminology that we'll come to in more detail when we sort of, in the next module when we look at case law, but whether cases have been applied, distinguished, discussed, etc., etc. So don't worry about that quite yet, but it's very, very important to understand those terms. And again, the databases are very helpful these days in terms of the way they put signals up as to how different cases have been considered. So please note that the catchwords and the head notes are usually prepared by legal publishers, and so it's not actually part of the judgment itself, but sort of a value add that is given. And then it sort of provides all the information about how the case came before the court. It notes who represented the different parties, and provides lists of the cases that have been cited, etc., and what the actual judgment was, whether that was on the same day, so extempore, or whether it's reserved for a later date. So again, it looks like a lot of theory, but once you become familiar with the layout of different cases, it'll become quite natural that you know where to look for specific pieces of information as you're sorting out the jigsaw puzzle. And so the judgment itself, there's obviously has the information about the legal matter that was before the courts. It provides the different issues, it presents the facts, and it sort of discusses the relevant law, etc. So that's concluded then with sort of the names of the solicitors and firms, and we'll have the initials or the name of the reporter who then wrote the catchwords and head notes. So that sort of pulls that little lot together. So as I say, on the Blackboard site, there's a lot of materials for you to have a look at to begin to understand some of these things. There's some tables that we've presented there, a whole list of tables based on the different jurisdictions, from the sense of the geographic jurisdictions, of some of the main tools that you might want to begin to look at in terms of finding legislation and finding case law, etc. So that's all been put together to try and help you navigate through the landscape of all the different materials in the different jurisdictions. That's quite a useful place for you to start. Any questions on that? It's very factual. It's sort of the basics, the foundation things that you do need to be aware of and to know about. I see. It all seems quite straightforward. I say the best thing is to sort of, just read through the notes and then go and look at some real pieces of legislation and some regulations and some law cases, and start introducing yourselves to those materials. But we'll help you with some exercises, of course, as well, that will guide you through that process. And there's a few sort of readings that are listed there as well. All of the chapters, all of the textbooks that we've got, they've all got information as well about this process. It's sort of, in a way, just foundational to understanding law in this country. Now you've got all of those acts and regulations and cases. I mentioned that it was really important that within the courts, all parties are singing from the same hymn sheet, so to speak, have got the same documents. So identification of legal documents and how they are referenced and cited is very important. Most of you would be used to academic referencing in terms of APA, so or Harvard or Cambridge, etc. There's lots of different referencing schemes that you have used through your studies. But there's now legal citation, which is a little bit different, but follows the same sort of formulaic approach that we expect in other referencing styles. So what we'll very quickly look at is what is a citation, and then consider the different rules and show you where to find the rules as they apply to the citation. And there's lots of abbreviations that you'll become familiar with over time. Okay, so a citation is really critical in the law environment, so that it's how any statement of law is referenced. And so you do need to know in your legal research very, very early on how the law is referred to by solicitors, by judges, by people writing about the law. So there's a report of a case, the section of an act, the clause of a regulation. There is a set way, a standard way of doing these things, and it's referred to as citation. So a law case that's cited in court is considered that legal authority for things. So it is a fairly standard way of doing things. So once you're used to it, it becomes quite normal, but you do need to be able to work through the different rules and the different conventions. Naturally, the real goal is to ensure uniformity and consistency so that everyone refers to the same materials. Electronic information is encouraging greater standardization, which is probably a good thing. Now, the two main documents that you need to be aware of, there's the Australian Institute of Judicial Administration, or the AIJA, and they have a guide to the uniform production of judgments. And then Melbourne University Law Review Association has got what's referred to as AGLC, so the Australian Guide to Legal Citation. So the AIJA guide is about case law, and it gives you the format for judgments, the importance of uniformity of catchwords, things that librarians quite love in terms of standard vocabulary, and then a style guide, which gives you some guides about how to refer to the different legal materials in different ways. The AGLC, this then gives you some details here around the different aspects of different legal materials, again, the primary materials and the secondary materials. It has been adopted, you can't read this, I understand that, but the AGLC methodology has been adopted by all of these different legal journals. So it really is common practice across published legal research activities to follow these. So you will come across it everywhere. There's work on a new edition at the moment, AGLC. I'm not sure, we might ask Richard later on about the progress that's being made there, sort of to developing it. There's been quite a lot of consultation with the law community, law library community around that through their e-list and also a hashtag there. So it's important to note that sometimes law schools have their own sort of minor modifications. So if you look at the referencing materials on QUT library website, there's something called SiteWrite, QUT SiteWrite, which gives you guidance on Harvard APA and QUT legal. So you can have a look at that as well. So that's a helpful go-to place to find out how to do things. So most law schools will provide help in this area for their students. So again, we stress that things have to be accurate, and the citation can get more complex. There's a note there around there can be duplication of case names. For example, with tax cases where the same parties are involved, sort of the person who's sort of taking the tax office to task, and there may be several areas of issue, and so it's got same party names and then case number 1, number 2, number 3, number 4, etc. So you need to be able to identify those as well. And so a lot of punctuation has been stripped back. If you look at older legal materials, there were lots of full stops and underlining in various things. These days it is much more simplified. Just hold on a minute, please. My apologies, I'm using somebody's office and the cleaning lady came in for the bin. I wasn't expecting that. So yes, so double check, make sure that you are familiar with the ways to do things. Create your own cheat sheet. And these slides can help you, I think, as we go through. So I'm not going to go into lots and lots of detail because I think it's something that would be, you need to work through some examples. And that's why we've got some exercises for you during the week. One term to be aware of is a pinpoint reference. And that is the reference to either a specific page or a paragraph or a footnote. So it might be the section of a legislation is referred to as a pinpoint reference. It might be the page in a law book, or it could be sort of in secondary materials a reference to a particular thing. So we'll just skip through some of these very quickly to show you the main points that you need to be aware of. So legislation, it can depend on how it's published. Paper version versus online. In the old days, we don't really have very many CD-ROMs, but there are databases for things that need to be cited, or just online websites. And here, so through these slides, you'll find these little tables, and this is the formula, if you like, of how things need to be set out. So the middle line gives you need the title of an act, the year of an act, the jurisdiction, and then potentially a pinpoint reference. And the rules below that give you where in the AGLC3 you will find the information if you want to clarify something. So an act, they have the example there of the Crimes Act, 1958. It's a Victorian statute, and they want to make reference through the pinpoint reference to Section 3. And there's some examples then below, so Evidence Act, 1995, etc., etc. So what you need to notice is that the use of italics is important there. The name of the act and the year of the act are in italics. The jurisdiction is not in italics. Okay, so that's the key things to note. The abbreviations for the jurisdiction are standardized as well, so that table gives you the appropriate way of referring to the different Australian jurisdictions. So you don't make up your own. So that just gives you step by step the same information. So the short title of the legislation, the year that the act was passed, now that's receiving assent. So if you've got the sort of end of the year, something might have gone before Parliament in December, but actually only receive assent in January of the following year. So that's important to be aware of, that when you're looking for extrinsic materials, for example, for explanatory notes, where the second reading speech, the year might actually be a year out, sometimes even longer. It can take longer to receive assent. So there's some information on that. And there's just a screenshot of Protection of Cultural Objects on Loan Act 2013, the Commonwealth Act, and it's Act number 12, 2013. And then it's got the short title. We talked earlier about short titles and long titles, and how the long title is read through the House in the first reading, second reading, and third reading. So the short title is that it's Protection of Cultural Objects on Loan Act 2013, but the long title is it's an act to encourage the loan of objects from overseas for temporary public exhibition in Australia. Da, 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 da. Okay. So notice on the actual legislation they don't use italics. It's when you're citing the legislation that you move across to using italics. So you would present it that way. We've got a few minutes, so we'll just put a couple of slides there for you to have a go at your own, if you like. So I'll just give you sort of a few seconds to have a look at this one. How would you cite this act, if you've got paper and pencil there, to think about how you would refer to that? And again, you can note that there's a short title and then the long title are provided. You can come back to these afterwards if you want to. So there's that one. The Fortification Removal Act of 2013. So it's amazing what this is a Victorian Act. It's amazing what legislation does cover when you sort of start drilling down into the statute book. And then we've got a Western Australian Act. So you can see how the different acts in the different jurisdictions are actually published in slightly different ways in terms of how they're laid out. That's an important one, the Supply Act. And there's the Queensland Act, the Succession to the Crown Act 2013. You can see here the difference between the long title and the short title is quite substantial. Okay. So there's some answers to the questions. So the bail, sorry, that's wrong. You see, I can actually see there's an error there. That was my test for you. New South Wales should not be in italics in that. So it's Bail Act 2013, New South Wales. And then Fortification Removal Act, etc., etc. I will correct that one. So online materials, not legislation per se, but if you were referencing, for example, the Australian Guide to Legal Citation, there's an indication there how you do it and how you use angle brackets for the URL to do that, and there's no need to sort of write the date of the visit. Okay. So that's just the short title information. So I'll skip through these a little bit to show you the... Interesting. I actually ripped the backing off some of these, but it's for the backdrop. The other thing to notice, and you'll have seen that in all of the examples we showed you just now, the number of the act is often referred to as well. So acts are given a number in the sequence of the legislation as passed or as receiving royal assent. So we do talk about acts as passed, so it'll have an actual number, and that's another finding tool for you to be able to locate a certain piece of legislation in the listing for the year of the acts that are provided. Okay, the bills, similar, very, very similar, but notice a bill does not have italics for the title and the year. So you can identify straight away whether it's an act or a bill when it's cited by the lack of italics there. And that's just some examples. Explanatory notes, explanatory memoranda, etc. There you use the term explanatory memoranda, then the citation of the bill, followed by, if there is one that you're looking for, a pinpoint reference. Delegated legislation, again you've got back to some italics there for the title and the year, and then you have your jurisdiction and then how it's referred to as a regulation or an order, and there are appropriate abbreviations for all of those to consider there as shown in that table. So all of these different terms are used in different situations. So order, regulation, rule, sub-regulation, sub-rule, etc. So be aware of those. Then the other area is around the cases. So as court cases, there's a set way of looking at those. Again, you've got the elements in that middle line as it goes through: the case name, the year, the volume if there is one, then the abbreviation of the law report series, a starting page, and then if there is a pinpoint reference, you'd have a comma followed by the actual page of what is being cited there. Okay, so under the year, you can notice that there's a difference between those with round brackets, as in the first example, and square brackets in the second example. So if you move across to the next column, you'll notice that the CLRs, there's actually a volume number 237. So in that situation, you know that there's a volume to go to. The Victorian reports don't have volume numbers, so you're navigating by the actual year, not by the volume number. So the way in which that is then presented is different. Probably seems a bit complex, but you'll get used to it. And that just provides that explanation. Just to note, the V that's put in between the two party names is referred to as AND. So it's K Generation Proprietary Limited and Liquor Licensing Court. Of course, Kramer versus Kramer and those type of things. In America, it's called versus, but in Australia, it's AND. And that just explains the difference again between the round brackets, whether it's got a volume number, it's in round brackets. If there is no volume number, it's in square brackets. So that's here. There again is the authorized report series. And what you need to note here is that they have changed over time. So if you look at, let's just look at Queensland in the middle there. So QSR was an earlier series of authorised reports from 1902 to 1957, and since 1958 it's the Queensland reports, so big Q, little d and R. So you can see how you might very well need to go back to earlier series of authorised reports as well. Because of the journey of Australian law, very often going back in time, you do need to refer to English court reports. So you need to be able to locate those as well. So again, they're standard abbreviations for the different series of reports. You'll find that all of the legal resources have got tables of abbreviations that you can refer to in your early days of doing it. If you're in doubt, there's some really useful guides to the abbreviations as well. The Cardiff Index, I spent the weekend in Cardiff, there you go. Cardiff Index to Legal Abbreviations. The Monash University LibGuide has got a very good overview. And CaseBase, one of the online tools for legal research in case law, they've got their abbreviations there as well. There's also some information here on unreported decisions. So these are decisions which are not published by the legal publishers or through the councils of law reporting. And there's a standard way of referring to those with the case name, the year, the court identifier. So you haven't got the actual report series, you're linking it back to the court itself. A judgment number as handed down, and then the full date of the decision. So the concept that a medium neutral citation means that it's not in any particular medium. It doesn't mean medium meaning halfway between low and high. It's medium as in media. So it's not aligned to any specific media. And here again you can get some information about the details there. You will again see some older ways of doing things. The original citation method is different to the current one. So this slide just gives you an example of how older ones might be referred to, because you're likely to come across them in different legal research scenarios. And just to be aware of how the titles of judges are abbreviated as well. So Chief Justice, or the Justice of the various courts, and the plural of one justice is actually the two J's together. Court of Appeal has a president, and then a judge of the Court of Appeal, and a district court judge. So you'll see those used around, so you need to be familiar with those. So in your own time, on the Blackboard site, we've got a series of exercises for you to become familiar with this process. So it's a really foundational skill that you need to master. So we encourage you to spend some time in the week ahead working through these, and then we'll sort of do a bit of a debrief at the beginning of the class and check that you're on track and that you've not had any problems along the way. So if you could get that done by next Wednesday, that would be wonderful. Again, it's pretty heavy weather working through these bits, but as we say, legal citation is a critical component of legal research, and you need to get your head around it from the beginning, which is why we introduce it to you fairly early on, so that you don't get too confused. Has anybody got a question at all? Okay, so again, you can let us know as you go if you've got any problems. Let's take a quick break if we just make it 5 minutes. We've got Richard is already with us, our guest for this evening, and we're going to talk to him. There's a photo of Richard. So it's, according to my computer, it's 4 minutes at the moment, so let's get back just after the hour, or the half hour in South Australia. So if you want to put up your away signs and then go and have a quick stretch, and then we'll come back and interview Richard and find out all the things that he's up to. Talking away in the background.